There are certain informational questions which an attorney will generally ask their clients. They are important questions because these questions can come up later, they can be important in pleadings, and they can even be important in the case of a client suddenly disappearing. I'm going to go through some of the questions which I ask about a client's contact details and those of other parties in a matter. I will ask a client's full names as per the identity document, and the as per the identity document is quite important because quite often people use names which are not the same name as they have in the population register. And in the Birth States Registration Act of, I think, 1993, it sets out that someone can use a first name which isn't their first name in the population register, and people often do that. So you might have a client's name which is whatever it might be, and that's not actually their name as per the identity document, and that can become quite important if litigation becomes involved, or if letters need to be written, or if a will or antenuptial contract or something else needs to be drafted. It can also be quite important in making sure that you invoice them correctly. You then have a client's maiden name, especially with a woman. And the maiden name is also important in that when you are suing someone with their maiden name or suing on behalf of someone with their maiden name, you'll usually mention it. You will say their name, then in brackets, ne, which is French for born, it's N, an E with a little stripe going forward above it, and then another E, and then you say the name, the maiden name, and close the brackets, and that means the name they were born with, the surname they were born with. And then you also want to know any previous names. These previous names or maiden names are actually quite important as they can come up in a matter, and it's important to know them so that there's not confusion in future. And finally, it's a good idea to ask a client their preferred name. I find that a client's preferred name is something which they will want you to call them and talk to them in email and so forth with, and it's something useful to have. Then you want their identity number if they're South African, or their passport number if they are someone who doesn't have a South African identity number. In any case, you're going to be asking things such as an identity number for the case of money laundering compliance, which I plan to do another presentation on. And you then would want their date of birth. Date of birth is important for several reasons, including establishing that someone has majority status and is therefore able to take certain actions. And if someone doesn't have an identity number, quite often you need to say their date of birth. So, for instance, many an antenuptial contract will involve a foreigner's date of birth when they don't have an identity number, and many other deeds, such as transfer of property, might also have something like that. You want to know what your client's nationality is. Nationality is quite important, and both for your client and for an opponent, especially with an opponent, as they might leave the country and then you might not be able to sue them as easily. So it's quite an important thing to know. It's also important for statistics purposes. You want to know their occupational job. When you are suing someone, you say that so and so, an adult male accountant with the following address, is suing you, and you respond of who you are with your pleadings, whether or not that's true, and with the opponent, you also want to know their occupational job because you're suing them as an adult male accountant or adult female um, banker or whatever it might be. There you also want to know the age of your client. Now your age, date of birth, and identity number are going to have some similarities, so it's also useful to double check, but it can also be useful for statistics purposes. In certain types of suing, the government demands that you fill out statistics forms for them. You want to know the sex of your client. Obviously, for any pleadings, you have to say if the person's male or female, and it's useful in other ways as well. You need to know the race of the client. Again, government statistics demand that you give the race of a person who is suing in certain cases, especially in divorces. you need to know whether or not someone is married. This is quite important as it restricts how they can sue depending on whether they're married and the type of marriage. Now, so you need to know whether they are married. Then the marriage type, you're looking at, are they married in community or property? Are they married under accrual? Are they married with exclusion of community or property and of accrual? And if someone has an anti-nuptial contract, depending on the type of matter, it can be quite useful to look at it because sometimes there are restrictions placed in there as well. I know I certainly place certain restrictions in anti-nuptial contracts that I do, which are not just answered by saying that there is the accrual system. There might be more complexity to it. Then you have the marriage details. When did they get married? Where did they get married? Was it in a church or was it with the government? Which type of church were they married in? This can be useful for statistics purposes, and it can also be useful in general. You want to know your client's cell phone number, their personal one, their telephone number, their fax number, their email address. You want to know their home address and their postal address. All of these are quite important for getting hold of the clients if you can't find them. And things such as the addresses are important for the purposes of suing on behalf of the clients and so forth. So they're quite important overall. You then want their workplace. Again, a workplace can be important for suing, as you can say someone's work address in certain cases. And also when suing someone, you can serve them at their work address in a number of types of litigation. So their workplace, what's its name, their work email, their work telephone number, their work fax, their work address. Then their spouse's name, their spouse's maiden name, spouse's age, ID number, date of birth, sex, race, nationality, telephone number, and email address. These can be quite important, especially if it's a matter where the spouses are married in community or property and you might need some sort of permission from the spouse to proceed. Then you want to know the domicile of the husband at the time of the marriage. That determines whether South African law or another law applies. The domicile, it comes from the Latin word, I think, domos, for house, and it essentially is the last place that the person considered to be their permanent or indefinite address or place of existence. So if someone's domicile is South Africa, South African marital law applies if it's the husband, and if it's not South Africa, then the domicile determines which law would apply. So it can be quite important, as people might think that they're married in a certain way, but they might be married in a very different way. Then you need to know if the spouse has ever negotiated or entered a customary marriage. This is quite important, and it's actually come up in within some of my work, and it's in particular with an anti-nuptial contract. I had some of my clients go through to a traditional leader who confirmed that they were not yet married in accordance with the tradition of their specific tribe and culture. And I then got them to do affidavits stating the situation and stating that they had not consented to be married in customary law, which is one of those elements which are important involving a customary marriage, that if you have consented to be married in customary law, then you can be married, but if you've not consented, then it's something which can be used to say that they aren't married in customary law as they both haven't consented. And in any case, the marital ritual in terms of that custom had not taken place, whereby the woman is introduced into the man's family house in that specific type of tradition which I'm referring to now. You look at whether or not you have the spouse's permission to instruct where necessary, and I put in brackets in my own form, community or property. This is a form I fill out. It's not a client which fills out this form. You need the spouse's address, spouse's occupation, spouse's workplace and address. These are important if you need to sue on behalf of both spouses and for other purposes as well. You then want your client's alternative contact person. Now, this can be quite important. I've actually had cases where a client disappears and you don't know how to get hold of them, and it's an important thing that you need to get hold of them for. Well, what do you do then? You have a duty towards your clients, and you have a duty to get information from them or to represent them, or to stop working for them, but you need to be able to contact them in all these regards. And I've actually found I've had a client disappear and then you don't know what to do about it, except you collect the alternative contact person name, and this is quite important. And so you get the alternative contact person name, you get their cell phone, a number, their telephone number, their email, and their fax, if they have a fax. Most people don't anymore. And then you need to find out, may the alternative contact person be given confidential information, because an attorney operates on confidentiality and we have to keep our clients' information confidential. But where we're given permission, it can be useful to be able to discuss things with that alternative contact person in the best interest of your client. So if a client is a company, I have that I'd also fill this out for a sole proprietorship or a partnership, etc. So the question is, are they a company? In which case the person whose contact details you're getting would be the contact person, but the company would be something separate. And you also need to know this for the purposes of money laundering legislation, that's FICA, or the Financial Intelligence Center Act, and a number of the things which you're collecting for the client and for a company are things which you'd be collecting in any case for the purposes of FICA, though I plan to do a different presentation on that. You need to know the name of the company. You need to know its registered number if it's one which is registered with the Companies and Intellectual Property Commission, the CIPC that is. You need to know the type of company. Is it a old Section 21? Is it nowadays a not-for-profit company? Is it a closed corporation or CC? Is it a private company? Is it a public company? Is it a state-owned enterprise? Is it a corporate body? Is it something else, such as a trust? And I think Hirsch's Home Store is in fact a trust. If you look at the details, I might be giving the wrong store, but it was interesting. I saw an invoice from one of these stores a while back, and it was a trust. You need to know what its status is. Is it in trading or is it not? Is it undergoing automatic deregistration for non-compliance? What are the details? You can get this sort of thing from the CIPC website. You have to give your ID number and a few other things, and you can get those details for free from them. Or you can use things such as Searchworks or Windeed to get that sort of information, though you're going to be paying with Searchworks or Windeed. What's the registration date of the company? And are you authorized by the company to see the person on their behalf who you are seeing? This can be quite important, and quite often you just have the directors do a board resolution or something along those lines, and you need to get access to that in order to proceed. You need to know the registered address of the company and the postal address. These sort of things are on the CIPC website if you access it. And you want to know the trading address. Now, a company can be sued from its registered address, or it can be sued at its main place of business. This is quite important when you're suing someone, and it's also important to know for your own clients. Then I have a section in my own form where I ask for directors and details, or relevant details if a CC, that's a closed corporation, body corporate, curator, administrator, guardian, executor, trust, partnership, etc. And there you're looking for the details of the directors quite often. You want to know their names, you want to know their ID numbers, and their addresses and so forth, which you can get through things such as Searchworks or a director search using the CIPC possibly, or through Windeed. Windeed is owned by LexisNexis. LexisNexis used to also have its own separate deed search type of function, but now it's Windeed and Searchworks who are the main competitors in the market. You need to know what their previous attorneys are for the matter, and possibly ask in general, and this can be quite important. I've had a matter where a client was accused of certain violent acts and accused of being a sociopath or a psychopath. And we were possibly going to sue for defamation because of these claims which were being made by the opponent. And it turned out from a previous court case that the person had sued for the loss of their conscience for the fact that they've become a sociopath in a car accident, and that their own witnesses had testified to this, and that they had gone to court with this, and that the opponent had the details of the court case involved in it. So it can be quite important to know of previous cases involving the client, even if they're not directly related. If they are directly related, it can be quite important to know about the previous attorneys, because you need to talk to them and you need to know what's happening in the matter, and you need to get documents from them. And if there's a lien over the documents, the client needs to pay them what's owing to those attorneys so you can continue with the matter. It can also be important to know if there's previous attorneys, because there might still be the attorneys on the matter, and you can't take a matter if there are already attorneys dealing with it ethically if you're an attorney. So then you want to know the reference that those attorneys use for the specific matter. As many attorneys have thousands upon thousands of matters, it can be useful to have that code so that they can know exactly what matter it is. You need to know the attorney on the matter, their cell phone, telephone, fax, email, and the address of the firm, and their reason not currently on the matter. That's quite important because it can often give you a lot of insight into the matter and into the clients in question, and sometimes it's a stage at which you'll say, you know what, I shouldn't be taking this matter after all, because the reason that attorney is not on the matter is a reason why you shouldn't be on the matter. Then you want to know what files and information those attorneys would have, and any relevant notes, to-do list, or other details, etc. in relation to the previous attorneys. Now, I tend to have in my own little editable PDF that I use for my own clients, I tend to have 4 times that specific list, which I've read to you from, for up to 4 clients or up to 4 preliminary people. I then have another 10 input pages for other parties to a matter. That's your witnesses, that's your opponents, that's other parties who are involved but who aren't your clients, and it can be quite important to get those details as well. There you want to know the reference they use for the matter, and you also want that for your clients, obviously, and you will have your own separate reference, which is your own reference for a matter. You want the full names per identity documents, maiden name, any previous names, preferred name, and yes, it can be important to refer to an opponent's witness or other party by their preferred name, as this can influence how things go forward, as it can create a sense of cordial and amicable cooperation, rather than calling them by, say, their first name when they don't like their first name. Their identity or passport number, their date of birth, nationality, occupational job. Obviously, you need to cite them by their job when you are suing them. Their age, sex, race, married type, marriage details, cell phone, telephone number, fax, email, home address, postal address, workplace, because you might be suing them and serving upon the workplace and therefore citing it. Work email, work telephone, work fax, work address as well. So the workplace name and all of these details of it. The spouse name of this other party. Spouse maiden name, spouse age, spouse ID number, spouse date of birth, sex, race, nationality, telephone number and email, domicile of the husband at the time of marriage. Obviously, your client's not going to know everything, but they often know more than you expect that they know. Did the spouses ever negotiate or enter a customary marriage? Spouse's permission to instruct where necessary in community property. This can be quite important. It's especially important if you have parties who are entering into, say, a contract of sale, and you want to have the permission in terms of a spouse married in community of property. I've actually found this quite useful in discovering that I needed that, and then I got that permission included and had the spouse also sign the contract of sale of a company for about 800,000 Rand between the 2 parties. So it was quite important to have those details so that contract wouldn't suddenly become invalid. Spouse address, spouse occupation, spouse workplace and address, and then the other parties, alternative contacts, person's name, cell phone, telephone, email, fax, and whether or not that alternative contact person may be given confidential information. This can be quite important if you can't get hold of another party in a matter and you need to get hold of them. And sometimes things can become very suddenly urgent. If they're a company, etc., and I also say for sole proprietorship, partnership, etc., so you say what they are, and then the name, registered number, type, status, registration date, authorized to see the firm. Now, it could be your firm or the firm who they are suing you through or being sued through, or your client through, or so forth. Registered address, postal address, trading address, I've dealt with those already. Then directors and details, or relevant details if a CC, corporate body, creator, administrator, guardian, executor, trust, partnership, etc. Then you want to know who their attorneys are, the reference they use, their attorney on the matter, cell phone, telephone, fax, email, and address, and other relevant details. With all of my matters, I will also have a further details box in which I can just fill out more and more details of these contact details nature, both for my clients and for other parties in a matter. And these other parties lists and or client lists can also be important in another sense. Let's say you're drafting a will. It can be incredibly important 40 years down the line to have the details of the witnesses to the will, to have the details of the executor and the heirs and so forth available to whoever's wrapping up the will. So it can be useful to fill out all of these details and then to include them in the envelope which has the will in it, so that it becomes easier to sort the will out. Some other details I collect for my own purposes are: is this the client or the client's contact person, the nature of the matter, my own reference, the date I opened it, is the matter resolved or not, the attorney on the matter name, and I often go with the parties involved, the fee structure. This can be quite important because you might agree to a very specific fee structure for a matter and you want to give all of the details of that in case it becomes disputed later or in case you forget about it later. I also deal with encryption passwords. I say ideally a unique 12 plus character code, and either having it agreed with the party at the actual consultation or to have it sent to them via text message or WhatsApp. And that code then unlocks any documents which you send to them, which would be 256-bit encryption, which is one of the safest degrees of encryption you can get. And what you then do is, if you're sending a bill to a client, you will specifically have a password protection on it. And quite often people's emails are hacked and bills are replaced with incorrect banking details in order to get money from a person. And if it's a lot of money involved, such as thousands or tens of thousands of rand, then it can be a very big problem for your clients. And it can be very problematic for them to try and sue and get the money back again, and it can be an expensive process, as the bank's not just going to give the money back. So it's important to be aware of those sort of scams, and I've actually seen examples of such a scam where a party paid a good amount of money into the bank account of a creditor and the money was never received by the creditor, so the creditor was proceeding with trying to collect it from them, and they said, no, I paid it, and then the two emails were printed out and it had different banking details on it, and it was interesting to see that. It's also important, as I've seen matters where, for instance, in a matter between an Australian company and an African company, where they were suing each other in South Africa, and where I was dealing with the matter along with my principal at the time. One of the, I think something like the deputy CEO of the opponent's company replied to an email that we'd CC'd them in, as the opponent's attorneys wanted us to CC their clients and everything. And they replied to it saying, I think they know about this and this. We should be careful of that. And the result was that they'd just given up their entire case, and that one email, which they accidentally emailed us with, lost them 20 million US dollars. So it's important when dealing with your own clients as an attorney to take precautions. It can also be that your emails to a client, let's say they only have their work address, and you email that, and then suddenly someone at their work checks their email and investigates it, as is often done in accordance with their contract at a company and so forth, and they get fired because they're being sued for something. I often find that if an attorney is representing someone in a domestic violence case, that person suddenly gets suspended or fired from their job for no apparent reason. So it's quite important for maintaining confidentiality. And also, I once had a client who wanted me to always CC them in everything, and I CC'd them in an email to the opponent, and then they did the same thing as that a deputy CEO did, and emailed back, including the opponent in it, some information which was only meant for me. And then I had to try and salvage that matter, despite the fact that the client had said some things that they shouldn't have said, which should have been protected by confidentiality, but which in fact went through to the opponent of the matter. So my approach, and I think it's an approach any attorney should take, is communications with your client should be via a PDF document, which is encrypted using a password they know. Banks often will use someone's identity number. The problem with that is if they are listed in the CIPC, if they own any property, if they're married and so forth, the identity number can be easily gotten. So it makes more sense to make them make up a password. The second part of this is what I call identification phrases. They're sort of core phrases to a degree. And when your alarm company phones you when your alarm goes off to find out whether or not they should send armed people to your house, they will ask you for an identification phrase or number, and you give them that phrase or number, and they know that it's you who's talking to them. So in any encrypted documents sent to a client, I would generally speaking include a identification phrase which the client would agree with me and make up during the matter when we have a consultation with them, and this can make them more certain that it's me who's communicating with them and that the document hasn't been corrupted. This isn't a perfect system. It can still be corrupted. It can still be someone else who's smart enough to deal with it or who knows about the details of it, but it's something which gives more protection. And also you can have a system if you want, depending on the complexity of the matter or the details of it, where the client, when they call you, gives a call phrase, a separate one from the one in the document, which identifies them to you as in fact being the client, and where you have a specific call phrase with that client which identifies you to them, so that it makes cell phone conversations safer but not quite safe. These things can still be gotten around. There is a lot more information which an attorney would want to get from their clients during a consultation, and there are the statutory requirements of the Financial Intelligence Centre Act, which are also important. But here are some of the basic things which it's advantageous for an attorney to gain from their clients, and which over the years I have created as a list which I use with my clients. I hope that this has been useful. My name is Marc Evan Aupiais. Thank you for listening. As always, nothing in this presentation constitutes legal advice, and nothing in this presentation should be relied upon as legal advice. For legal advice, please make an appointment with your attorney and brief them fully on all of the nuances of your particular matter. Thank you very much.